afternoon, or evening, depending upon where you are. Or morning, middle of the night. Guess all depends. But anyways, I broadcast live from East Coast. My name is Mark Kulak, KULACZ. And this is my little show, Houstonic.live, and it is a Friday afternoon here. Friday, September the 8th, year 2023. And we are going to continue on with a part 6 of our reading the 2023 Yale Law Journal article titled The Antibody Patent Paradox. Hope everyone is doing well. Thank you for joining me. A couple of quick updates before we dive in. And these updates are useful in understanding the context of this effort here. And it's sort of direction that we are definitely going in right now, which is bringing a lot of attention to the patent issue. We are going to get a better understanding. We are going to create sharper and more accurate hypotheses about what the heck is going on in the world and what went down with respect to COVID-19 the more we dig into this. And I know this is a direction that very few other channels are going in, and that is totally okay. But a couple of updates that I think will help reinforce why we are going in this direction and reinforce or help build your confidence that this is the right track to be investing your time in. First off, as I said before on other shows, as on other broadcasts, this is number 664, I think. Hello Christy, hello All the Sun, hello Jeffrey, and hello John G. First, so there's several things I wanted to just highlight here before we get into the reading, and we're going to resume with we're about 2/3 of the way done with the section called "The Law is Following Changes in the Science" in the Antibody Patent Paradox. Okay, first thing is I just shared a 2014 video on my Rumble channel and on the BitChute channel called The Patent Wars. Now, this is a film that stars or features David E. Martin, and there's some good stuff in there. And David Martin, probably the most I've seen him present in a film, probably up until the movie plan or documentary, if you will, Plandemic, which was in 2020. It starts off surprisingly with the big focus on the ability to patent genes. Can you or can you not patent genes? The video as a whole covers several other areas which seem to be a little bit more disconnected with the current task at hand as it goes on. It's about a 1 hour and 20-minute video. But I found it fascinating that it starts right off with effectively gene therapy. It's like right up front. So the topic of gene therapy and patenting genes has been on the mind of David E. Martin of MCAM, M-CAM in Charlottesville, Virginia, for quite a while. Probably at least 20-something years. He spoke before Congress, or at least the United States House of Representatives, in 2001 regarding a biotech issue. And if you just look at several of the other rulings, one was actually an opinion piece written by MCAM, I think it was in the year 2014 or 15, on a company called Celgene, Celgene. And I'm not kidding you. It was actually about a drug which is has been modeled on its approval by the FDA based upon thalidomide. Like, wow, okay, that really hits home. The other thing I wanted to say is that while searching for this 2014 video called Patent Wars, sometimes my dyslexia winds up working to my favor. I'll read one thing, and my mind is pretty convinced that it actually sees something completely different. Okay? And this is, when I was looking for the movie The Patent Wars, I found another movie, a longer film, a documentary called The Patent Scam. the patent scam. And you can watch this. It's a 1 hour and 50-minute video. You can watch this on the channel called Gravitas Free Documentaries. Gravitas Free Documentaries. It's still on YouTube. I don't know why I was able to watch it without paying anything. Perhaps it's because I have the YouTube Premium set up. Good video, all right? Now, initially when I watched this, I'm like, okay, so what's the angle here? Because I thought I was actually watching the patent wars video. And this movie and the patent scam video made no mention of David Martin, so I was a little confused. But I've watched a little bit of it last night. JJ Cooey watched a little bit of it. Actually, I think he watched the whole thing yesterday or this morning. There's a big section in here on mediation and arbitration. All right. I haven't watched that section myself, but it highlights how important the mediation and arbitration is right now with respect to the U.S. legal system and its impact on patents. Patents are, I mean, you know about how there's this mining of patents. We know about how there is like phishing, if you will. We know that there is overreach. There's a lot of issues and problems with the U.S. patent system right now. But the patent itself only really has value when it comes time to enforce it and how enforceable it is and whether or not you're doing the enforcement or you're the subject of the enforcing, right? And, of course, the little guys tend to get crushed more often than not in this particular case. And this documentary clearly highlights that. However, it also brings up the topic of arbitration. And arbitration is when things are settled not by a judge, right? And when things are not settled by a judge, well, that means that no precedence is being set for future rulings. Why do we bring this up? Bring this up because it's almost as if a selective legal system is evolving via the implementation and enforcement of the patent system. Companies, if you want to call them corporations, non-government organizations, dictators, whatever you want to say, can selectively enforce justice on the population or rules on the population, and then other times can choose to simply do whatever they want because two companies or a company and an individual may simply go to arbitration and not set any precedents for future rulings. So there is a serious problem now with the patent system, in addition to the fact that it has these problems of its bill. It's not really that compatible with, let's just say, personalized medicine. And that's a big part of the antibody patent paradox, okay? It is the patent system is sort of in the way for using technologies to collect data for future, for the future of medicine. That's another part of what's in the way right now of the patenting system. But also, I'm going to really walk out on a ledge here and say, if you were trying to, or if you were part of the implementation of effectively, I'm going to use some pretty bold words here, a communist takeover of the United States of America, you can use selective targeted enforcement and sometimes arbitration of the U.S. legal system of U.S. patents to accomplish that goal. You can use the patent system to bypass a lot of law. It can work in your favor. So there's multiple dimensions to why the patent system and how the patent system is being misused and how the patent system and understanding these nuances, which we are learning together, they're not just, they may sound like nuances, but they're really going to be big. They have been big, and they're going to continue to escalate in magnitude with respect to the operation. At least I know my whole audience is not in the United States, but the function of the United States of America. It's a really important issue. And as Brett and Eric Weinsteins, you know who they are. Father, Les Weinstein, is one of the top arbitrators in the United States of America. This is where he comes in. They can effectively agree, companies between each other or between themselves and governments or whomever can agree on whatever they want and leave the law out of it and not even impact the enforcement of patents on future people that may want to challenge them. This is really scary stuff. So when you see so many people with the, at least in the past anyways, communist or globalist leanings, you know, and now they are within the circles of patent enforcement, you should be very scared. You should be, or let's just say scared. I don't want people to be scared, but you should be on alert. You should be on alert. This is not just about some companies wanting to protect patents so they can make a few more dollars. And it certainly isn't what David Martin was suggesting early on, which is Ralph Barrick was sloppy in the lab and wanted some money to buy a new Camry. That's certainly not it, okay? The patent issue is huge. Now, if you don't think antibody patents are big, if you don't think this issue of antibody patents are big, Robert Malone, in this interview with, I forget the hostess's name, I apologize, says some really startling things. So we're going to listen to Jay's little clip here before we get into the reading for today's show. Okay, guys?
Just put out a Substack about Eris, which is one of the two variants, the other one being Corolla. This is absolute fear porn, initially kicked off 2 weeks ago.
I don't like that term.
By
I hate
Scott
that
Gottlieb,
word, fear porn,
acting on behalf of Pfizer in what was essentially an extended commercial on Face the Nation. What we clearly have here, and I've documented in that Substack essay just the day from the CDC, that phylogeny relationship of this Eris variant to Omicron and to the variant that they have built the booster vaccine, quote unquote, products for this fall. And by the way, the statement that was made in the first clip about neutralizing antibodies, that's, I'm sorry, I don't know what else to say. That's BS. Neutralizing antibodies are not a correlate of protection.
I want you to consider, and thank you, Jay, for finding this, and you can see the shock on his face. Robert Malone just went the last 2 years. He had 2 years to talk about neutralizing antibodies. He had 2 years to talk about neutralizing antibodies. And after, I've had my foot on the pedal about this patent issue, in particular, the Antibody Patent Paradox. After we've had our foot on the pedal about the Les Weinstein's role in antibodies and protein patent issues between Centocor and Orthobiotech and Genentech. After Jonathan Cooey, for the last few weeks, also has been on the patent issue. And even though I've heard through the grapevine that some people says that we are off our rocker focusing so much on this, now, after 2 years, Robert Malone is saying the role of neutralizing antibodies is effectively a myth. Think about that for a second. Now, I know that Cooey and myself are somehow we didn't make the threat list of Robert Malone. I don't know why. However, I'm seeing Robert Malone significantly alter the type of stuff he's saying, and it feels as though it's in response to the stuff that only a very few channels, probably count them on your fingers, even if you chop one off with a table saw, you could probably, I believe we are impacting this message here. This is really amazing. So after 2 years of not talking about it, now it's enough of an issue to say, hey, this whole neutralizing antibody thing, forget about it. Wow. Now, is he talking about antibodies overall, like a whole? Is he just talking about the entire model of immunology? In which case, what have vaccines been doing since the beginning of time? I thought again, this isn't my belief, but I know what I've heard, and I have heard since the beginning of time, the whole point of vaccines is to give you the antibodies and your body's protected. How many stupid biology books have drawn these pictures for us? Or is he only talking about monoclonals? I don't know. This is really out there. And if Malone had recently come to some epiphany, and maybe he was wrong, which is what we all do. We all make mistakes. We go down wrong paths. We believe the wrong thing. We change what we believe based upon things that we learn. And that would be cool. But he's talking as if he's always known this. Like, duh. And now he's got to reconcile that? This is really freaking amazing stuff. So I am so thankful that Jonathan found that for us. Okay. Now, I've been making some suggestions lately that I think there's been some cooperation between Robert Malone and David Martin. People are just blown away. Like, why? Well, first off, they've been touring together, been seen to be side by side and complimenting each other a lot in a weird way. They certainly never speak negatively of each other. So there's that. There's the fact that David Martin, in early pandemic and early COVID-19 videos, was talking very specifically about patent lawyers in the United States Department of Justice Antitrust Division, which is effectively a shout out to the role that Les Weinstein has had for a big chunk of his career, father of Eric and Brett Weinstein, and the fact that Robert Malone's big coming to the forefront, coming to everyone's worldview, happened on the Weinstein show, the Brett Weinstein Dark Horse podcast show. Okay, that's loose correlations. And we can go down a few other things about companies that David Martin has commented on, etc. And you're going to see why we're bringing this up, right? How we bring this up to the current task at hand, okay? So David Martin's company, MCAM, and a matter of fact, his initial business ventures of David E. Martin were in Charlottesville, Virginia. Now, I didn't know there was a Charlottesville, Virginia. Obviously, I'm not much of a history nut. I only learn things on demand. I always thought there was just a Charlottesville, North Carolina. And so there's Charlottesville, Virginia. And what I didn't know is that Charlottesville, Virginia is where Monticello is, the home of Thomas Jefferson. And I didn't know that Thomas Jefferson, I think I might have heard this before, but I never really thought about it, was the person who signed and effectively got the patent system rolling within the United States of America, some would say. He didn't design the patent office, but he felt it was an important part of America standing on its own 2 feet. So Charlottesville, Virginia has a history with Thomas Jefferson, Monticello, and the early implementation of patents. Now, I don't know if that's why the state of Virginia has decided to invest so much into the transfer of intellectual property from its educational facilities into U.S. patents and corporations. If it's decided to do that in Charlottesville for some reason based upon history, well, I don't know. Okay, I don't know. But maybe it's one of the reasons why David Martin's decided to found his company, MCAM, in the Charlottesville, Virginia area. But what I didn't know until I just did a little bit digging around here. Let's see here. Let me open this up here. And I just tweeted this yesterday. Is that, let's see here. Do I have the map here? So when Robert Malone did this tour to talk about Zika drug repurposing in 2016, he's actually pitching his company called, I think it was called Alchem. It was, let's see here. It was the company just before Alchem. I'll have to dig in. And the company was based in a little town of Scottsville, which is just south of Charlottesville, Virginia. So Malone has effectively been living within 20 miles of Charlottesville since 2010. So right around the time that the antibody issue was really starting to pump up with the Centacor case, Malone relocated the family to Virginia within a short distance of Charlottesville, Virginia. First, it was the company was based south in Scottsville, and then they got the horse farm in Madison. So in addition to this, again, I know it's loose correlation. I'm not saying that I proved anything. However, it's noteworthy that Malone has effectively been orbiting around MCAM and David E. Martin for 12 years plus right now. And when they were doing the presentation on this company that Malone had started for drug repurposing for Zika virus and how they were going to use computers for it, he was presenting to the Charlottesville, Virginia Business Council, which is which is almost the same council that David Martin effectively was working on to some extent. They've rebranded themselves a few times ever since 1998, 1999, but still, it's interesting. And they are been touring. Who pays these guys to go to Europe next side by side and hot tub together? I know they don't want to be seen as a unit, and I think it's kind of odd, but I'll tell you what, physical proximity usually means a lot. Okay, now one could make a case that, hey, I live close to Moderna. Well, I kind of do. Okay, I moved to Massachusetts for the computer industry. You could make that case if you want to. Knock yourself out. I would understand. If someone wanted to take that angle. But in this case here, looking at this, I was just blown away. So there is, I believe, some collusion. And it may not have been directly with David Martin, because I think there's a variety of other intellectual property businesses and experts in the Charlottesville, Virginia area. But I believe that there's a very good reason why Robert Malone and his wife Jill have decided to build their life in this particular vicinity. Something strange, just some gravity to these resolution of intellectual property issues in Charlottesville, Virginia. We're going to figure it out over time, but I always wondered, why did he present to this little tiny group? No offense to them. It's not like he's going on tour presenting at every little town of 50,000 people. It just never resonated. It just didn't make any sense. Now it makes sense because we've been looking into David Martin. Now, also, the David Martin issue, he has a pretty rich, if you go through the older blogs of the MCAM company that David Martin is on, you'll find a reference that his grandfather was his best friend and one of the most influential people of his life. That's cool. I'm there, dude. I'm there. I am forever trying to honor my own grandfather, my own mother's grandfather, or father, excuse me, John Raymond Dorsch, who was a police officer and a detective in the city of Bridgeport, Connecticut, for his career. And so when I was trying to figure out who David Martin's grandfather was, I kept looking at the paternal side, and his paternal grandfather was a farmer, honest to God, farmer in Pennsylvania, and lots of Mennonites. And it's it's, as I've mentioned, it's actually a very, very strong Christian family. But how is it that, according to his own blogs, his grandfather was an attorney and represented people who were in the United States Supreme Court? So then you dig around, and sure enough, his maternal grandfather was actually named William Herbert Parsons. Maternal, excuse me. And he was an attorney in the Washington, D.C. area. He was born in Washington, D.C., and he died in Silver Spring, Maryland. His obituary has been wiped. His father, William H. Parsons Sr., was born in England, came to the United States, worked in the insurance industry. His obituary has been wiped. And we know that based upon some World War II draft certificates, that the person that David E. Martin's grandfather worked for was George F. Snyder. And George F. Snyder just actually obviously died a long time ago. But he was born in 1901 in in Pennsylvania. And then in Washington, D.C., he practices law, specializing in patents. And at times, he constitutes the entire Washington graduate chapter of the University of Pennsylvania, nearly all of it. While again, we find 150 Fijis, I guess that's what they call them, these particular graduates. So he was a heavily impactful United States Supreme Court expert, if you will. He was with the United States Supreme Court, and his specialty was patents. So now George F. Snyder is not related to David E. Martin, but this is the office that William Herbert Parsons Jr. had worked for. And then William Herbert Parsons went on to work as an attorney for Canadian Pacific Railroad through the 1950s and 1960s, which doesn't necessarily mean trains. Canadian Pacific started to divest into communications during that time, but since his obituary has been wiped, who knows? What we do know is that if you look at the home address, it is actually 1/4 of a mile from the headquarters of the FDA in Silver Spring, Maryland. So the granddad, if you will, the grandfather maternal of David E. Martin is decided to build his life around living-wise the FDA building in Silver Spring, Maryland. So this is just all little interesting data points, just trying to highlight to you or impress upon you again how connected many of the people who have been put out in the forefront are to patent issues. We can see how they've been responding, changing their tune after 2 years plus to now talking about antibodies, talking about whether or not they work or not. If you go back in the past, you'll see that lots of proximity, similar proximity, or living in the same areas, working on similar issues. I think we are going to continue to see the apple cart being kicked over, and apples being kicked all over the place, and the cart set on fire, because there's a lot of very frustrated people right now that we are focusing on this issue. It would be better if we were focusing on nanobots or using 5G communication to reprogram people's DNA, or P3417 alpha omega cancer genes all over the place. Instead, we are going right into the intellectual property, the foundation, which is being challenged and rebuilt right now. And we didn't decide for all the people in the Truth, Health, and Freedom and Transparency Hero Medical movement to be connected with patents. But that's the way it was. And sometimes you just have to look at what's right in front of you. I have to look what's right in front of me and go, well, what do all these people have in common? Patents, intellectual property, in particular, how to either use the patent system in combination with things like mediation, arbitration to effectively facilitate, amongst many things doing this, right, many tools, the communist takeover of the United States of America, or to usher in a new era of medicine, which is really not about helping anyone at all. It's really about mining the general population for data. So to potentially to contribute to the future era of medicine. Okay. The law is following changes in the science. A third possible explanation. Again, we're listing the three different reasons, going all the way back to the beginning of this chapter here. It listed out three things of what's going on here. We did A, we did B, now we're in C. A third possible explanation is that the change in the validity of functional antibody claims reflects changes in scientific knowledge about antibodies. On this theory, neither patent owners nor the law intended to claim all possible antibodies that bound to a particular antigen. Rather, in the early days of antibody research, inventors did the best they could practically do in describing the valuable new thing they had discovered, and the best they could do was to identify the antibody by defining an antibody as, quote, the thing that attaches to this antigen we have identified, unquote. The Federal Circuit allowed those claims not because it intended to give ownership over a vast, poorly defined genus of molecules, but for pragmatic reasons. Function was the only practical touchstone researchers could use to describe a particular antibody that the patentee had, in fact, identified. As the science advanced, however, it became easier to identify the attributes of a given antibody in more detail: its three-dimensional structure, the particular epitope to which it bound to the antigen, the specificity with which it bound, and so on. Those attributes were introduced into claims as they were discovered, further narrowing the particular antibodies as inventor had identified. But now that researchers can routinely identify the underlying DNA sequence of a particular antibody, under this account, patent claims should be limited accordingly. This theory has the virtue of aligning the Federal Circuit's recent work in the area with its older cases. Defining antibody claims as narrowly as the science allows avoids the problem of broad genus claims of intermediate scope. It narrows functional claiming to its smallest practical and specific factual circumstance, while still allowing claims to be written in functional terms when necessary. It is, perhaps, analogous to how courts have historically treated product-by-process claims. They allowed claims that covered a chemical product to be written in the form of, quote, the product produced by process X, unquote, when all that was known about the product is how it was made. Those claims traditionally cover the product as a whole, however made, but the Federal Circuit has more recently read them to cover the product only when made by that specific process. There, too, courts might be responding to changes in the science, allowing a patentee to describe their claims by the manufacturing process when that was all they knew about the product at the time, but narrowing claims as the science advanced and they could describe the product directly. Such a theory also offers an alternative to an outright reversal in Federal Circuit doctrine, an explanation of why the Federal Circuit might transition over time from allowing functional antibody claims to soundly rejecting them. There's a problem with this theory, though. There is no indication that this is what the Federal Circuit thinks it is doing. To the contrary, all of the court statements suggest that it is concerned and has always been concerned with identifying molecular structure. At least according to Judge Lurie, nothing has changed. Quote, it has always been, or at least has been since the Patent Act of 1870 that a patent applicant must enable one's invention, whatever the invention is. What is new today is not the law, but generic claims to biological materials that are not fully enabled, unquote. Perhaps, but from that perspective, the shift is paradoxical. Potentially broad antibody genus claims were permissible when we knew virtually nothing about the molecules, but the more we learn about them, including what to do with them, the less we can claim. This is the article's titular paradox, or titular paradox, and the opposite of how both the enablement and written description doctrines normally work. This might mean that, despite the enormous economic value of new antibodies, there can no longer be a valid genus claim covering them. We know now that there is no simple relationship between the molecular structure of different antibodies capable of binding to the same epitope in similar ways, so claims covering functional outcomes will necessarily cover widely different gene sequences. On this story, the conceptual work of antigen identification and antibody discovery is simply a first step. It is not the invention of a genus. Instead, the inventive act today is homing in on a specific, common genetic structure of practical use. Nor are we likely to see structure-based antibody genus claims in the future. Antibodies are composed of billions of different proteins, more than the number of genes in the genome, 10 million times over. Path-breaking innovation decades ago, like Kohler and Milstein's Nobel Prize-winning work, allowed researchers simply to identify and produce antibodies generally. Path-breaking biologics innovation today concerns sequencing and optimizing a single antibody, and there is no clear relationship between the structure of any of those billions of proteins and the binding function they perform. That is an amazing statement. There is no clear relationship between the structure of any of those billions of proteins and the binding function they perform. That is a rather bold statement in an era where I hear many people say, it's the ACE2, it's the furin cleavage site, it's the binding, it's the ACE, it's the furin. Sorry, narrator's frustration note is over. There simply cannot be a valid claim to a structural genus under this theory. While the Federal Circuit and Judge Lurie have promised that claims directed to antibody genera are not dead if the patentee just discloses enough structural similarity, that promise has so far proven illusory. And as a matter of advancing science, there is no good reason to think that it will always be illusory or illusion inducing. So let's do D as well. Finish up this third section. The drug pricing backlash. Also noteworthy that you're going to find a lot of discussion in the movie The Antibody, and not The Antibody, but the patent scam about drug pricing issues. You'll also find drug pricing issues in the Patent Wars documentary that mostly stars David Martin from 2014. And clearly, I mean, this is something that we feel. Although before I even read the section, I'll say I think there's more going on behind the scenes than what it may seem at the surface. But let's read this section here. Okay, the drug pricing backlash. A fourth possible explanation for restricting antibody patents is grounded in the real politic of drug development. Wry-eyed court watchers might suggest that the Federal Circuit's doctrinal turn regarding antibody patents is in response to public ire over pharmaceutical patents and drug pricing. Antibody therapies are, of course, enormously expensive. Humira, the world's best-selling antibody therapy, stickers for $77,586 per patient per year. About 2 Teslas worth. Well, maybe the very small Teslas. Globally, antibody therapies netted their manufacturers about $157.33 billion in the year 2020. And while the relationship between patents and prices for biologics is complex, especially given the fractured United States healthcare system, patents are certainly a significant component in that equation. The public has digested this information and turned its bile on drug manufacturers who are routinely vilified in the press and increasingly on Capitol Hill. It is difficult to imagine that the judges on the Federal Circuit, sitting 2 miles from the halls of Congress in a famously clubby town, have failed to notice. But there is no compelling reason to think politics are driving the court's decisions. The political story doesn't explain why the appellate court upholds some biologics patents and not others. Nor is there any easy trend line between cost of antibody drugs or profits reaped by their developers and which franchises suffer invalidated patents. The anti-PCSK9 antibody therapies at issue in Amgen versus Sanofi, which is Repatha, or evolocumab, and Praluent, Praluent, or alirocumab, are rather inexpensive, all things considered, but the Federal Circuit invalidated Amgen's claims regardless. Humira, by contrast, is wildly expensive, getting more expensive still, and yet its patents have largely been upheld. Lastly, such a political explanation doesn't address why, of all provisions in the patent statute, the Federal Circuit chose to make its stand on Section 112, the source of the written description and enablement requirements. Other validity doctrines, like obviousness under the, again, I think it's Section 103, but hopefully I'm reading that right, are widely available in antibody cases. A court interested in burying outcome-focused decisions has much better and subtler ways of doing so. Moreover, such political explanations are a bit too thin. They are not so much a portrait of judicial realism, but a landscape of judicial nihilism. For all our criticisms, the Federal Circuit seems legitimately troubled by the scope of antibody claims. Ignoring such realities entirely would better serve claims to judicial realism than grappling with them in case after case. And the court has not, traditionally at least, radically shifted patent doctrines on gross policy analyses. Quite the contrary, it has from time to time gone out of its way to deny political motivations. If anything, the court has a political reputation for protecting the patent system. It would seem odd, therefore, that a political explanation for this doctrinal shift ends up destroying some of the patent system's most valuable assets. In short, while there are several possible explanations for the antibody patent paradox, none of them is completely satisfying, either as descriptive matter or as a justification for the change in the law. So the last section is going to be Section 4, Resolving the Paradox, and we're going to do that in the next reading. So with that said, guys, thank you very much for joining. God bless. Have a great night. Stay positive. Love each other. if you're lucky enough to have a good friend or a good spouse or whatever, take a moment of prayer and thank the Lord, or whoever you want to thank. Thank the great oak tree in the yard. I don't know, that you have been fortunate enough to be blessed with having an angel in your life. I did that today. I'm grateful for what I have. Thank you very much, everyone. We'll be back with part 7 very soon, and have a great weekend. God bless.